What is labor law? And how do you talk about work and rights in legal English? In this beginner legal English class, you will learn key terms like contract, employer, and salary. You will also practice using the present simple to describe basic labor rights and workplace responsibilities. Perfect for anyone starting to explore employment law in English. We know learning legal English as a beginner can be very difficult. That's why we built a step by step course in school. Join our school community to build your legal English skills with lessons, live webinars, and a forum so you can finally speak legal English with confidence. Here is what you will learn in this class. First, you will learn important vocabulary for labor law. Words like employee, employer, contract, and benefits. These are basic legal terms used all over the world. Then, you will practice describing what people can and must do at work, like following schedules, receiving pay, and understanding contracts. And finally, we will work with the present simple tense. This grammar helps you talk about what happens every day at work, like job duties or company rules. By the end of this lesson, you will feel more confident talking about work, contracts, and labor law in clear, simple English. Let's begin with some simple questions about labor law. First, what is a work contract? It is a legal agreement. It says what the job is, how much money the worker makes, and the rules of work. What should an employer give an employee? Things like a safe workplace, fair pay, and rest breaks. These are labor rights. And what do workers do every day? Well, that depends. They might serve customers, use computers, drive trucks, or work in a factory. These questions will help you connect your own experience to the new vocabulary and grammar you will learn today. Let's begin with the word contract. A contract is a legal agreement between a worker and an employer. For example, my contract says I work 40 hours a week. That means the law protects this promise. Now, imagine this. You start a new job at a law office. On your first day, your boss gives you a document. It says how many hours you will work, how much money you will earn, and what your duties or obligations are. You both sign it. That document, that is your contract. It is not just a piece of paper, it's your legal protection. If there is ever a problem, the contract explains what is fair. That is why contracts are so important in labor law. Next is the word employer. An employer is the person or company that gives someone a job. For example, the employer gives the workers a schedule and their salary. That means the employer is responsible for organizing the work and paying the workers money. Let me give you a picture. Imagine a bakery. The owner of the bakery hires 5 workers. She tells them when to come to work, what to do, and how much they will be paid. She is the employer. Whether it's a small bakery, a big law firm, or a government office, the employer has power, but also responsibility. And labor law helps make sure employers treat workers fairly. Now, let's talk about the word employee. An employee is the person who works for an employer. If you have a job and you get paid, you are an employee. For example, employees must arrive on time and follow the rules. That's because employees agree to do the work in the contract. Think of Anna, a legal secretary. She comes to the law office every weekday, Monday to Friday. She answers calls, prepares documents, and helps the lawyers. She gets a salary every 2 weeks. Anna is an employee. She has a contract, a schedule, and legal rights. Labor law protects employees like Anna. It says they must be paid, get breaks, and work in a safe place. And it also says employees must follow the rules in their contract. Next is the word salary. A salary is the money a worker receives for doing their job. It is usually written in the work contract. For example, my salary is paid every month. That means you get paid once a month, not every day or every week. Let's imagine Carlos. He works at a law firm. He answers emails, files documents, and supports the lawyers. At the end of every month, he receives $800. That money is his salary. Some people get their salary every week. Others get it every 2 weeks. Labor law often says there must be a minimum salary, a basic amount that an employer must pay. Now, let's look at benefits. These are the extra things a worker gets besides their salary. For example, the job has good benefits like paid holidays. So even when you are not working, for example, you are on vacation, you still get paid. Here's a story. Rosa works for the government. Her salary is $900 a month, but her job also gives her paid holidays, medical insurance, and a year end bonus. These extras are her benefits. In many countries, labor law says that workers must get certain benefits, like paid sick leave, vacation time, and sometimes Social Security. Benefits make a big difference in a worker's life. It's not just about the salary, it's about protection and support too. The next word is hours, the time you work each day or week. It includes when you start and when you finish. For example, I work 8 hours a day from 9 to 5. That's a common office schedule in many countries. Let's talk about David. He is a legal assistant. His contract says he works 40 hours a week. That means 8 hours a day, Monday to Friday. He starts at 9 a.m. and finishes at 5 p.m. with 1 hour for lunch. These are his work hours. Labor laws often say there is a limit, usually 8 hours a day or 48 hours a week. If you work more than that, it's called overtime. A break is a short rest during the workday. It helps you relax, eat, or drink coffee. For example, we get a 15-minute break in the morning. Picture this. Sophia works at a courthouse. Her day is busy, answering phones, talking to clients, preparing forms. At 10:30, she stops for 15 minutes. She drinks tea, checks her phone, and sits down. That is her break. Breaks are important for health and safety. And labor laws often say when and how many breaks workers must get. In Costa Rica, for example, if you work a full day, you usually get a lunch break and one or two short rest breaks. Let's talk about overtime. This is the extra time you work after your regular schedule. For example, we get more money for overtime work. Let's say your contract is for 8 hours a day, but one day your boss asks you to stay until 7 p.m. That's 2 hours of overtime. In labor law, working more than your regular hours usually means extra pay. So, if you stay late, the law often says the employer must pay you more, sometimes 1.5 times or even 2 times your normal rate. Overtime protects workers. It's okay to work more sometimes, but only if it's fair and paid correctly. The word resign means to choose to leave your job. It's your decision, not your employer's. For example, I resigned from my job last month. Let's imagine Mariana. She worked at a legal office, but she got a better offer somewhere else. She told her employer, I am going to resign. She gave 2 weeks' notice, finished her work, and left the job politely. Resigning is a part of labor law. In many places, you must give notice, usually 1 or 2 weeks before you leave. It's part of being professional. Now, let's talk about the word fired. This is when the employer tells you to leave the job. It's not your choice, it's their choice. For example, he was fired for being late too many times. Think of Luis. He was late many times. He did not follow the office rules, and he did not improve. After some warnings, the boss fired him. In labor law, getting fired can be serious. Some workers may receive severance pay, money when the job ends. And in many countries, employers must have a good reason and follow legal steps. Let's practice some sentences with questions to help you find the right word. I will read each question and you think about the answer before I tell you. Who pays you money every month for your work? That's the employer, the person or company that pays you. If you work for a company, you are the, yes, you are the employee, the worker. What do you call the legal paper that says how many hours you work? That's your contract, the written agreement. Who is your boss or the company that gives you a job? That's your employer. What extra things like paid holidays or health insurance do you get? These are your benefits, extra support from your job. Now, let's do a true or false activity. Listen to each sentence, then decide if it's true or false. Overtime means working fewer hours than normal. No, that's false. Overtime means working more hours than normal. Employees must follow the rules at work. Yes, that's true. Following rules is part of the job. A break is a short time to rest during the workday. True, breaks help workers stay healthy and focused, and it's their right. You get paid more money when you resign. False. When you resign, you choose to leave. It usually does not come with extra pay. A fired employee leaves the job because the employer wants them to. That is true. Being fired means the employer ends the contract. Great work! You are getting stronger with labor law vocabulary. Now, let's talk about the present simple tense. We use this tense to describe actions that happen regularly, facts, or things that are generally true. For example, I work in a law office. That means it's my regular job or routine. She signs contracts. This tells us what someone regularly does at work. Because we are learning about labor law, many sentences talk about jobs, contracts, and work routines. Present simple helps us say those clearly and simply. Here is how to make present simple sentences with I, you, we, and they. We use the base form of the verb, no S at the end. For example, I work on contracts. This means it is what I do regularly. You follow labor laws. You do this as part of your job. We prepare meetings. That's something we do often. They explain benefits. They tell people about extra help at work. This is the basic way to talk about regular actions. When we use he, she, or it as the subject, we add s or es to the verb. For example, he signs the contract. This means it is what he does regularly. She explains the benefits. She talks about the extra help workers get. It finishes at 5 p.m. This could be the office or meeting that ends at that time. And remember, verbs ending in ch, sh, x, o, or ss get es instead of just s. For example, watch becomes watches, finish becomes finishes. This small change is very important to speak and write correctly. Let's start with some idioms, and we'll start with on the same page. This phrase means that people agree or understand something the same way. In a labor law context, it's important for employers and employees to be on the same page about contracts and job expectations. For example, before the meeting, we made sure we were on the same page about the contract terms. Being on the same page helps avoid confusion or problems later. Now, a legal phrase, at will employment. This means either side, the employer or employee, can end the job whenever they want without giving a reason. This is common in some countries like United States, but not everywhere. For example, in many states in the United States, employees work under at-will employment contracts. Understanding this is important when talking about job security and rights. Let's look at collective bargaining. This is when employees negotiate together with their employer, often through a union, to get better pay or conditions. It's a key part of labor law because it helps balance power between workers and employers. For example, the union uses collective bargaining to improve worker salaries and conditions. This process can lead to important changes in the workplace. Here's an idiom, call the shots. This means to be the person who makes important decisions. In the workplace, the manager or employer usually calls the shots about tasks and schedules. For example, the manager calls the shots in the office and decides the work schedule. This phrase helps us talk about who is in control. Here's an idiom: cut corners. This means to do something faster or cheaper, but usually not as well or by ignoring rules. In labor law, cutting corners can mean ignoring safety rules or not following contract terms. For example, the company cannot cut corners when it comes to employee safety. It reminds us that shortcuts can cause problems. Get the ball rolling. This means to start something important, like a meeting or project. In the workplace, it is used when people begin talks, plans, or work. For example, we need to get the ball rolling on the new contract negotiations. It's a friendly way to talk about starting action. Let me tell you a story about Maria's first day at a law office to bring together everything we learned today. Maria arrives excited to start her new job. First, she signs her employee contract. This document explains her salary, her work hours, and her duties clearly. It helps Maria know exactly what is expected. Next, her manager explains her job description, the list of tasks she will do every day. Maria listens carefully because she wants to understand her role well. Her manager, who calls the shots in the office, tells Maria which tasks to do first and how to follow the company's labor laws. This means Maria promises not to cut corners. She will do her work carefully and follow all the rules, especially for employee safety. The team also makes sure they are all on the same page about schedules and responsibilities, so there is no confusion or mistakes. Finally, Maria is ready to get the ball rolling on her new role. She feels confident and excited to start contributing to the team. This story shows how important contracts, clear job rules, following laws, and good communication are in a workplace, all essential parts of labor law. Before we finish, let's review what you learned today. First, you practice important vocabulary about labor law, including words like employment contract, job description, employer, salary, and duties. These help you talk clearly about jobs and work rights. You also worked on present simple verbs and learning when to add s or es for he, she, and it, and keeping the base verb without the s for I, you, we, and they. We talked about who calls the shots at work. It means who is in charge and makes decisions. You also learned other useful idioms like cut corners, get the ball rolling, and to be on the same page. Finally, we saw how clear contracts and good communication protect both workers and employers, making work safer and fair. Great job today. Keep practicing these words and phrases to build your legal English skills. We know that learning legal English is difficult. Please join our school group for easy lessons, live webinars, and a supportive forum, and start speaking legal English confidently. The link is in the description. In many countries, labor law protects the rights of workers and explains their responsibilities at work. Job descriptions, contracts, and interviews often require lawyers and HR professionals to explain these rules in English. In today's lesson, you'll learn the basic vocabulary for workers' rights and responsibilities, and you'll practice using must and have to, two very common structures for talking about legal obligations. By the end of today's lesson, you will understand and use common employment law words like staff, wage, and job agreement. Practice using must and have to explain rights and duties. For example, the employer must pay wages. The worker has to follow safety rules. Learn key legal phrases such as minimum wage and safe workplace. This will give you the confidence to explain basic employment law in simple English. Imagine this. In a training session, someone asks, what must an employer do for the worker? What must a worker do for the employer? You explain, the employer must pay wages and provide a safe workplace. The worker must follow safety rules and complete the job responsibly. This simple conversation shows why we need today's vocabulary and grammar. A job agreement is the understanding or legal paper between the worker and the company. It explains what the worker must do, how much they will be paid, and their rights. For example, there is a job agreement that explains pay and hours. Imagine Anna starts a new job at a hotel. Before she begins, she signs a job agreement that says she must work 40 hours a week and will earn a certain amount of money each month. In formal English, this is often called a contract, but job agreement is a simpler and also common way to say it. Staff means the group of workers employed by a company. For example, there are 20 staff members in the office. Imagine, in a school, the staff includes teachers, secretaries, and cleaner. In a hospital, the staff includes doctors, nurses, and receptionists. Staff is a collective word, so you can talk about all employees together. A manager is the person responsible for making sure the staff do their jobs correctly. For example, the manager must check that the staff follow the rules. Imagine in a restaurant, the manager tells the waiters what to do, checks the kitchen, and makes sure the customers are happy. In a factory, the manager makes sure the staff arrive on time, wear safety equipment, and meet production goals. The manager represents the employer in daily operations. A wage is the payment a worker receives for their work. It is often calculated by the hour, the day, or the week. For example, the worker receives a wage every week. Imagine a factory worker earns $5 per hour. At the end of the week, he has worked 40 hours. So his weekly wage is $200. In professional jobs, people often use the word salary, but both mean payment for work. A shift is the set period of time when a worker does their job. For example, there is a night shift from 10 p.m. to 6 a.m. For example, in a hospital, nurses work in shifts. One nurse works the morning shift, another works the evening shift, and another works the night shift. In a factory, workers may change shifts every week. The word shift is very common when talking about jobs with rotating hours. Health and safety are rules that protect workers from accidents and illness at work. For example, the company must follow health and safety rules. Imagine on a construction site, workers wear helmets and gloves. In an office, workers have safe chairs and computers that do not hurt their eyes. These are all part of health and safety. The law usually requires employers to protect workers, and workers also have to follow the rules. Working conditions describe the environment and rules of the workplace. things like hours, safety, pay, and treatment. For example, the law protects fair working conditions for staff. Imagine, in one company, workers have clean offices, fair hours, and breaks. These are good working conditions. And another company, workers have very long hours, low pay, and unsafe equipment. These are bad working conditions. Employment law protects workers so they have safe and fair working conditions. Benefits are extra advantages workers receive besides their normal pay. For example, there are benefits such as health insurance and vacation days. Imagine a worker's wage is $500 per month, but the company also gives health insurance, paid vacation, and lunch at the cafeteria. These extras are benefits. Benefits are an important part of many job agreements. In English, we use must and have to talk about obligations and responsibilities. Must often sounds stronger and more formal. Example, the employer must pay wages. Have to also means obligation, but is used more in everyday speech. For example, workers have to follow safety rules. Imagine you are explaining job duties. You might say, the worker must sign the contract, or the worker has to arrive on time. Both mean the action is necessary. It is not optional. Let's look at more examples. The employer must provide a safe workplace. This is a legal duty. The worker has to complete tasks responsibly. This is a responsibility in the contract. Employers must respect contracts. This shows that the law requires employers to follow agreements. Workers have to respect company rules. This shows the responsibility of workers. Using must and have to helps you explain clearly what the law requires. The minimum wage is the lowest legal amount of money a worker can be paid for their work. Governments create this rule to protect workers from being paid too little. For example, there is a minimum wage set by law. Imagine in one country, the minimum wage is $5 per hour. This means that even if a worker agrees to work for $3 per hour, the employer must still pay $5 per hour because the law does not allow payment below the minimum. The minimum wage is one of the most important protections for workers, especially in low paying jobs. It guarantees that all staff receive at least a basic, fair payment for their work. A safe workplace means a place of work that does not put workers in danger. This includes safe buildings, safe equipment, and rules that protect workers from accidents or injury. For example, the employer must provide a safe workplace. Imagine in a factory, workers use machines. The employer must make sure the machines are safe, that workers receive training, and that they wear helmets or gloves. In an office, like we talked about before, this could mean safe electrical wiring, clean air, and chairs that protect the back. The employer does not provide a safe workplace, workers can get hurt, and the employer may be responsible under employment law. A safe workplace is one of the most basic rights of every worker. Equal treatment means that all workers must be treated fairly with no discrimination. Workers cannot be treated differently because of their gender, race, religion, disability, or other status. For example, workers must receive equal treatment. Imagine two workers do the same job. One is a man and the other is a woman. Equal treatment means they must receive the same pay, the same opportunities, and the same respect. If an employer pays one worker less only because of gender or race, that is discrimination, and it breaks the principle of equal treatment. This rule is a key part of international labor law and is protected in many countries. An employee handbook is a written guide that explains the rules and responsibilities of workers in a company. For example, there is an employee handbook in the company. Imagine a new worker starts at a company. On the first day, they receive a small book or PDF that says, "You must come on time. You must follow health and safety rules. You have the right to rest breaks and vacation days." The handbook helps workers understand both their rights and their duties. It is not always a legal contract, but it is an important document that shows company policy in clear language. Duty of care means that the employer must act in a responsible way to protect the health, safety, and well being of workers. For example, the employer has a duty of care to protect workers. For example, a company sends workers to drive long distances. The employer has a duty of care to give them safe cars, regular breaks, and insurance. If the employer ignores this duty and an accident happens, the company may be legally responsible. The duty of care is more than just health and safety rules. It is the general legal responsibility of the employer to think about the worker's safety and to take action to protect them. Let's finish with a story that puts everything together. A group of new staff begins work at a factory. Before they start, there's a job agreement for each worker. The agreement explains their wage, their working conditions, and their shifts. On the first day, the manager welcomes the staff and gives them an employee handbook. The handbook explains the rules. Workers must arrive on time. Workers have to follow health and safety rules. The employer also has responsibilities. The employer must respect the minimum wage and must provide a safe workplace. The company has a duty of care to protect the workers. All staff must receive equal treatment, no discrimination. And besides wages, there are benefits such as vacation days and health insurance. This story shows how rights and responsibilities work together. Employees must pay fairly and keep the workplace safe. Workers have to follow rules and do their tasks responsibly. By using today's vocabulary, grammar, and phrases, you can now explain the basics of workers' rights and responsibilities in simple English. Let's review everything you learned today. First, you learned vocabulary for work and employment law. You can now use words like job agreement, staff, manager, wage, shift, health and safety, working conditions, and benefits to describe the workplace in clear English. Second, you practice grammar with must and have to. These two small words are very powerful. They show obligation and responsibility. For example, the employer must pay wages, the worker has to follow safety rules. Third, you studied important legal phrases: minimum wage, safe workplace, equal treatment, employee handbook, duty of care. Finally, you used a wrap up story. You saw how workers and employers both have rights and responsibilities. Workers have to follow rules and complete tasks responsibly. Employers must respect wages, safety, equal treatment, and benefits. By combining vocabulary, grammar, and legal phrases, you are now able to give a simple explanation of workers' rights and responsibilities. Explaining workers' rights and responsibilities in English is a valuable skill for lawyers and professionals. In our legal English community, you will get full access to beginner, intermediate, and advanced courses, plus live sessions, and a private forum to practice with other lawyers and students. If you want to keep improving step by step, click the link in the description and join us today. In every workplace, time and money are two of the biggest issues. Workers want to know, how many hours must I work? How will I be paid? Can I get paid for overtime or holidays? Lawyers must explain these things in simple, clear English. Today's lesson will give you the vocabulary, grammar, and legal phrases to talk about wages and hours professionally. By the end of today's lesson, you will use vocabulary like overtime, schedule, paycheck, salary slip, holiday pay, break, part time, and full time. You will practice the present continuous, and you will learn legal phrases like work overtime, paid leave, maximum hours, wage dispute, and timesheet. You'll practice with a story where a lawyer helps workers understand their wages and hours. Imagine this: a worker visits a lawyer. He says, I am working 50 hours a week, but I am not being paid for overtime. He shows his paycheck and points to the missing overtime pay. He explains, sometimes I don't even get a break. The lawyer listens carefully and explains the laws about maximum hours and holiday pay. This simple story shows why wages and hours are so important in employment law. They affect every worker every week. Overtime means the extra hours a worker does after the normal work schedule. For example, she worked overtime to finish the project. Imagine a factory worker normally works 40 hours per week. One week, he works 50 hours. The 10 extra hours are overtime. In many countries, overtime must be paid at a higher rate, sometimes 1.5 or 2 times the normal wage. Lawyers often explain overtime rules to workers and employers so that everyone knows when extra hours must be paid. A schedule is the plan for hours and days of work. For example, the manager gave the workers their weekly schedule. Imagine a hotel worker looks at her schedule. It says Monday, 9 to 5, Tuesday, 1 to 9, Wednesday, free. The schedule shows when she must work and when she has time off. Schedules are important in employment law because they show the agreed working hours and can prove if a worker is being asked to do more than allowed. A paycheck is the money a worker receives for doing their job. It can be a paper check or a direct deposit into a bank account or cash. For example, he was happy when he received his first paycheck. Imagine an office worker opens her bank app on Friday and sees her salary is there. That payment is her paycheck. Lawyers sometimes review paychecks to check if overtime or holiday pay is included correctly. A salary slip or pay slip is a piece of paper or digital document that explains how a worker's pay was calculated. For example, the salary slip shows deductions for tax. Imagine a worker earns $500 in 1 week. His salary slip shows $500 gross pay, minus $50 tax, minus $20 Social Security, leaving $430 net pay. The slip is proof of what the worker earned and what was deducted. Lawyers may check salary slips to see if an employer followed the law. Holiday pay is the money a worker gets while on vacation. For example, she received holiday pay during her vacation. Imagine a worker takes 1 week off in December. Even though she does not work that week, she still receives her normal salary. This is holiday pay. Some countries also require higher pay if a worker must work on a public holiday. Lawyers often advise workers on their rights to holiday pay. A break is a short rest during the workday. For example, workers take a break after 4 hours. Imagine a cashier in a supermarket works from 8 a.m. to 4 p.m. She gets two 15-minute breaks and one 30-minute lunch break. Breaks are important for health and safety. If breaks are not given, lawyers may say the employer is violating labor law. Part time means working fewer hours than a normal full time job. For example, she has a part time job, only 20 hours per week. Imagine a university student works part time in a cafe. She studies in the morning and works 4 hours in the afternoon. She is not a full time worker, so she may not receive the same benefits. Lawyers often compare rights between part time and full time employees. Full time means working the standard hours each week, usually 40 hours to 48 hours. For example, he works full time as an accountant. Imagine a full time office worker works Monday to Friday, 9 to 5. He gets a regular salary, holiday pay, and other benefits. Many labor laws set rules based on whether a worker is part time or full time. Lawyers must know these definitions to explain workers' rights clearly. The present continuous is used to describe actions happening right now or things happening around this moment in time. The form is simple: subject plus is or are plus the verb and the ing ending. For example, she is working overtime. This is happening now. They are taking a break right now during work hours. The company is paying holiday wages this month, an action happening during this period. In employment law, the present continuous helps us describe what workers are doing at the moment or what is happening with their pay and hours. Imagine a lawyer visits a factory. He asks the manager, "What are the employees doing?" The manager answers, "They are working on the night shift." This tense makes the situation clear and immediate. Now, let's see the present continuous in real workplace situation. First example, a worker says, "I am checking my paycheck." That means he is doing this action right now, and maybe he notices that overtime is missing. Example 2. Union leaders tell a lawyer, "We are negotiating hours with management." That means the negotiation is happening during this period, not just one moment. Third example, a lawyer says he is asking about holiday pay in his contract. The client's question is happening right now. Now, the present continuous shows actions as they happen. It's very useful for lawyers and workers when talking about wages, hours, and even workplace disputes. Paid leave means the worker is not working, but still receives their normal salary. For example, she took paid leave for her vacation. Imagine an employee takes 2 weeks of holiday in July. During that time, she is not working, but her paycheck continues. That is paid leave. There are different kinds of paid leave. There's vacation leave, sick leave, maternity or paternity leave. Lawyers must explain workers' rights, when they can take paid leave, how many days are allowed, and what documents are needed. Maximum hours are the most hours a worker is allowed to work by law. For example, the law sets maximum hours for drivers. Imagine a bus driver works 14 hours a day. This is dangerous. The law may say the maximum is 8 hours per day or 48 hours per week. If the driver works more, the company breaks the law. Lawyers often use this phrase when checking if employers respect labor laws. Maximum hours protect workers' health and safety. A wage dispute is when workers and employers do not agree about payment. For example, the union filed a wage dispute against the company. Imagine, workers say, "We are not being paid for overtime." The employer says, "Yes, you are." This disagreement is a wage dispute. Sometimes a wage dispute goes to labor court. Sometimes it is solved in negotiation. Lawyers often represent one side in a wage dispute to make sure the law is followed. A timesheet is a document where workers record their hours. It shows when they start and finish work. For example, the lawyer checked the timesheet to confirm overtime. Imagine, a worker says, "I worked 10 hours on Monday." The employer says, "No, you only worked 8." The timesheet is the evidence. It may be on paper or digital, but it shows exactly how many hours were worked. Lawyers use timesheets in court to prove if overtime or breaks were respected. This phrase is key for solving wage disputes. Let's bring everything together in one story. A group of workers visit a lawyer. They say, "We are working 55 hours a week, but we are not receiving overtime pay." The lawyer asks to see their timesheets. The workers show records of their daily hours. The lawyer checks carefully and says, "Yes, you are working more than the legal maximum hours." One worker adds, "We also don't get our lunch breaks." The lawyer explains, "The law says you must receive breaks, and if you are working overtime, you must be paid extra." The lawyer writes a letter to the employer and says, "This is a wage dispute. My clients are asking for payment of overtime and proper breaks. If the company refuses, we will go to labor court." Later, the workers receive their missing pay in their next paycheck. This story shows how important it is to know the words and phrases for wage hours. They protect workers' rights and help lawyers explain the law clearly. Let's review what we learned in today's lesson. First, vocabulary. You practiced 8 important words about wages and hours. Overtime, schedule, paycheck, salary slip, holiday pay, break, part time, and full time. Regarding grammar, you use the present continuous to describe what is happening now, like she is working overtime or we are negotiating hours. You practice legal phrases such as work overtime, paid leave, maximum hours, wage dispute, and timesheet. And finally, we finished with a story about workers who went to a lawyer, showed their timesheets, and solved a wage dispute. Now, you can talk about wages and hours in English, clearly, politely, and with confidence. Welcome back to our Legal English series. Today, we're jumping into a topic that shows up in almost every law office and HR department: employment contracts and terms. Whether you're reviewing a client's severance package, drafting a non-compete clause, or explaining at-will employment, the terms you use matter, and so does how you explain them. In this lesson, you'll build the vocabulary and grammar tools to talk confidently about employment terms in a legal setting. Here's what we're focusing on today. First, we'll review key vocabulary terms that come up constantly in employment law: at will, non compete, and severance. Then we'll look at grammar structures that show up in contracts, especially verb patterns like agree to work, refuse to sign, and how they affect meaning. You'll also learn to tell the difference between defining and non defining clauses, a subtle but important skill when reviewing or drafting contract language. By the end of this lesson, you'll be able to explain the basics of employment contracts in clear, professional English, just like you would do to a client. Let's start with a simple question that opens up a lot of legal ground. What do you agree to when you sign an employment contract? Of course, there's the obvious: your job title, your hours, and your salary. But that's just the beginning. In most professional contracts, you'll find clauses that deal with how and when someone can be fired. That's what we call termination rules. There might also be confidentiality clauses to protect company information, or non compete agreements that limit where someone can work after they leave. As lawyers, our job is to understand these terms, explain them clearly to clients, and spot problems before they become legal disputes. So, in this lesson, we're going to dig into these key terms, what they mean, how they're structured, and how to talk about them like a legal professional in English. Let's begin with a key concept in employment law: at will employment. In an at will arrangement, either the employee or the employer can end the working relationship at any time for almost any reason, and they don't have to give advance notice. This is standard in many U.S. states, not so much in Costa Rica. You'll often hear employment is at will unless a contract says otherwise. But here's something important. This is very different from how it works in Costa Rica and many civil law countries in the region. For example, the default rule here is job stability and employee protection. Employees must justify terminations, give proper notice or severance, and follow strict labor codes. So, at will employment is not recognized here. You can't just fire someone because you feel like it. So, if a Costa Rican client asks, can I let this person go, this employee go tomorrow? As a lawyer, you need to look at whether just cause exists and whether notice or severance is required under local labor law. Understanding the difference between at-will systems like the United States and contract-based or statutory systems like Costa Rica is essential when advising clients. Now, let's look at another common clause in employment contracts: non-compete. A non-compete is a clause that restricts the employee's ability to work for a competitor or start a similar business after leaving a job. So, if someone says the company asked all executives to sign a non-compete agreement, it means those executives agreed not to take similar jobs or open competing firms, usually for a certain time period and within a specific location. These are very common in the United States, especially for higher level employees or people with access to confidential information. Employers use them to protect trade secrets, client lists, and competitive strategies. But now let's compare that with Costa Rican labor law and many countries in the region. In Costa Rica, non-compete clauses are extremely limited. They're generally only enforceable during the post-employment period if the employer pays compensation, usually 50% of the former salary for the duration of the restriction. And even then, they must be reasonable in time and scope. So, a U.S. client may expect to include strict non-compete terms in a contract, but here in Costa Rica and other countries in the region, you'll have to explain that clause won't be valid unless you compensate the employee and keep it narrowly defined. understanding these legal and cultural differences is key when reviewing or drafting international employment contracts. Let's finish this vocabulary section with a key term in both common law and civil law systems: severance. Severance refers to the compensation an employee receives when their employment is terminated, especially when it happens through no fault of their own, like layoffs or organizational restructuring. So, in English, you might hear the terminated employees receive severance based on their years of service. This type of payment helps employees transition financially while they look for a new job. In some countries, it's optional or negotiated. In other countries, it's mandatory. Now, let's look at Costa Rica. In Costa Rica, severance is not optional. It's part of the worker's legal rights under the labor code. If an employee is dismissed without just cause, the employer must pay. A pre-notice payment or work through a notice period, proportional Christmas bonus, which you know as aguinaldo, unused vacation days, and a severance payment, they call cesantía here, calculated based on the length of the time the employee worked for the company. And here's the key difference. In the US, severance is often negotiated or offered in exchange for signing a release. In Costa Rica, it's automatically owed unless the termination is for just cause. So, if you're helping an international client who wants to end a labor relationship here in Costa Rica, you'll need to calculate severance correctly and also explain it to the client correctly, and make sure the dismissal follows local law. It's a great example of how legal vocabulary connects to practical legal duties, especially across borders. Let's now talk about one of the core legal elements that defines whether a relationship is truly employment: subordination. In legal terms, subordination means the condition in which the worker is under the direction and control of the employer. The employer decides what work is done, when, and how, and the worker follows those instructions. In plain terms, if someone tells you what time to show up, what to do, and how to do it, you're in a subordinate relationship. For example, a key sign of an employment relationship is subordination. The employer sets the schedule and supervises the work. Now let's take a local example here in Costa Rica. Subordination is one of the three essential elements of a labor relationship, the other two being personal service and remuneration, or payment. And this is where the principle of reality comes into play. Even if the written contract says this is an independent contractor, if the worker is under constant supervision, works a fixed schedule, and uses the company's tools, Costa Rican courts may decide this is actually a labor relationship. So, as a legal professional, recognizing subordination means looking at how much control the employer exercises, because that control often determines the employer's legal obligations. And now let's close with the third key element of employment relationships: personal service. This term means the work has to be done by the specific person hired. It cannot be handed off to someone else. So the service is tied to the individual, not just the result. In legal English, we might say the contract required personal service, meaning only the named consultant could do the work. This is especially important when the job depends on personal skills or trust. For example, hiring a lawyer, a private chef, or a software developer. Now, how does this apply under Costa Rican labor law? Personal service is one of the three pillars that define an employment relationship. If a person performs the work personally, receives payment, and is under subordination, then legally it's considered an employment contract, even if the paperwork, the contract, says otherwise. So, if an employer signs an agreement with a contractor, but that person shows up every day, works under supervision, and can't send someone else to replace them, that's personal service. And that triggers legal obligations, minimum wage, social security, paid vacation, and more. Bottom line, if you're advising a client on whether a relationship is labor or civil, look closely at this. Is the work personal and non-transferable? That one question can completely change the legal outcome. Let's begin with a fundamental legal principle: substance over form. This means that in employment law, what really matters is how the work is done in practice, not just what the written contract states. For example, if a contract says this is an independent contract agreement, but the worker is controlled like an employee, working set hours, following directions, the courts will look beyond the words. They ask, what is the true nature of this relationship? That's substance over form. In Costa Rica, this principle is crucial because labor laws protect workers who are effectively employees, even if the paperwork tries to classify them differently. So, when advising clients or reviewing contracts, always focus on the actual working conditions and not just the label. This ensures compliance with labor law and avoids costly disputes. Next, let's talk about a common type of employment agreement: the fixed-term contract. This is simply a contract that specifies exact dates for the employment to start and end. For example, from January 1st to June 30th. Fixed-term contracts are often used for temporary projects or seasonal work. In Costa Rica, fixed-term contracts are legally valid, but they come with specific rules. Employers cannot keep renewing these contracts indefinitely without risking the contract being treated as permanent. The law also requires a clear reason for the contract's limited duration, like a temporary replacement or a special project. Understanding fixed-term contracts helps lawyers explain employment terms clearly and helps clients avoid misunderstandings or legal risks. Let's move on to a crucial aspect of ending an employment relationship: termination notice. This is the formal communication from employer to employee, or vice versa, that the job will end. Termination notice periods vary by law and contract, but their purpose is clear: to give time for preparation, whether to find a new job or a replacement. In Costa Rica, labor law requires employers to provide advance notice before terminating the employment without cause. Failing to give proper notice can mean paying compensation in lieu of notice. So knowing how and when to give termination notice protects both parties and ensures a professional, legally compliant exit process. Now, let's define the heart, the most important part of labor law: the labor relationship. This means a working relationship characterized by three core elements, which we've talked about: subordination, the worker follows the employer's direction; payment, the worker receives wages or salary; and personal service, the work is done by the individual, not delegated to someone else. If all these are present, legally, there's a labor relationship, which triggers labor protections like Social Security, vacation, and severance rights. In Costa Rica and other countries in the region, this is the foundation of labor law enforcement. Even if a contract says independent contractor, The court looks at these legal elements to decide if labor law applies. As legal professionals, understanding this helps you advise clients on contracts, employment disputes, and compliance. Finally, let's clarify the concept of independent contractor. An independent contractor is someone hired to provide specific services, but who operates independently from the employer. Key features include the control over how and when they work, using their own tools or resources, no subordination to the employer. This differs with an employee who works under the employer's direction and is covered by labor laws. In Costa Rica, the difference between an independent contractor and an employee is critical because labor laws apply only to employees. Remember, simply calling someone an independent contractor in a contract doesn't guarantee that legal status. Courts examine the reality, applying the substance over form principle we discussed earlier. So always analyze the facts carefully to determine the correct classification and legal obligations. Now, imagine a company hires a project manager for exactly 1 year to oversee a big construction project. The contract clearly states the start and end dates, no surprises, no automatic extensions. This setup is common when employers need someone for a specific period or task. What's the legal term for this kind of agreement? The answer is fixed term contract. This means the contract has a clearly defined start and end date. A senior sales executive leaves a company but agrees not to work for any rival firms for the next year. This protects the original employer's confidential information and client relationships. Such clauses are common in industries where competition is fierce. What do we call this kind of agreement? The answer is non-compete. It limits where employees can work after leaving. After years of service, a company informs an employee in writing that their contract will end in 30 days. This period gives the employee time to prepare and look for other opportunities. It's a legal requirement in many countries to ensure fair treatment. What is this formal communication called? Exactly. Termination notice, a formal notice that an employment relationship will end. Let's look at another one. When an employee is let go, the company offers extra pay or benefits to help during the transition. This compensation can help cover expenses until the employee finds a new job. Severance packages vary depending on contract terms and local laws. What's the legal term for this kind of payment? Severance. Exactly. It's money or benefits given after employment ends. Let's talk about something that comes up all the time in contracts and legal conversations. Verb patterns. Now, what do I mean by that? Well, some verbs are followed by a specific structure. For example, you might say, she agreed to sign the contract, not agreed signing. That sounds off. It doesn't sound right. And some verbs follow completely different patterns. In legal English, using the right pattern makes your sentence precise, natural, and professional. Let's look at the 3 most important types you'll see in contracts and legal writing. Let's look at these common patterns, like the verbs agree or refuse. They're followed by to plus verb. For example, the employee refused to accept the severance terms. That's the structure. Refuse to accept, not refuse accepting. Other verbs like consider or avoid need the ing form. For example, they avoided triggering a labor relationship. Again, if you said it avoided to trigger, it wouldn't sound right. These choices aren't random, they're built into how English works. But once you learn the pattern, it becomes automatic. Now, here's another pattern that's especially common in legal writing. Verbs like require, advise, or allow often follow this format: verb plus object plus to plus verb. For example, the contract required her to give termination notice. See that structure? The verb is required, the object is her, and the action is to give notice. This is one of the most precise and professional ways to assign responsibility in legal documents. You are not just saying what needs to happen, you're saying who needs to do it and what they need to do. Why does it matter? Because using the wrong pattern sounds unnatural and can confuse the meaning in contracts or negotiations. Let's talk about something lawyers use in almost every contract: relative clauses. They help us describe a person, a clause, or a condition with precision. And in legal English, that's everything. There are two types. A defining relative clause tells us exactly which thing we're talking about. For example, the employee who signed the contract started work on Monday. Now, a non-defining clause adds extra information, but it is not essential. It is not vital. For example, the client who arrived late missed the hearing. We'll go deeper into how and when to use each one. Remember, when the information is essential, meaning it tells exactly which person or thing we're talking about, we use a defining relative clause. That means no commas because the clause is part of the core sentence. Look at this example. The witness who gave testimony was credible. We're not just talking about any witness, we're talking about the one who gave testimony. That clause helps us define who we're referring to. This structure is key in contracts where precision is everything. Now, let's talk about non-defining clauses. They give us extra information. They're helpful, but not essential to understand the sentence. And grammatically, in writing, we show that with commas. For example, the lawyer whose office is in San Jose specializes in labor law. Even without the clause, the sentence still works. The lawyer specializes in labor law. We just added detail that his or her office is in San Jose. Non-defining clauses sound more formal, and they're used a lot in reports, legal memos, and witness statements. And here's a tip. In this kind of clause, we don't use that. We stick with who, which, or whose. Now let's get into my favorite part, idioms. Let's start with the idiom, bite the bullet. This phrase means you accept something tough or unpleasant, even though it's hard. In labor law, this can come up when someone is faced with job cuts, contract changes, or just a tough decision. Picture this. Your company is downsizing. You've been offered a severance deal. You don't love it, but waiting might be worse. You decide to just bite the bullet and accept it. It's about being brave in a tough moment. Here's another one. Throw in the towel. It comes from boxing, when a trainer throws a towel into the ring to stop the fight. In legal English, it's used when someone gives up, especially after a long negotiation or dispute. Maybe a union fights for better wages, but management won't budge. Eventually, the union throws in the towel. They stop negotiating. In law, this idiom often shows up when one party has no more options. Now, this idiom, hit the ground running, is all about starting strong. It means someone jumps into a project or job immediately and with full energy. Let's say a new lawyer joins your firm. On her first day, she's already drafting contracts and leading calls. She didn't waste any time. That means she hit the ground running. In the legal world, this phrase is often used to describe people who don't need much training. They're ready to go. And finally, let's talk about call the shots. This idiom means to be the one in charge. The person makes the big decisions. In a company, the board of directors usually calls the shots on things like budgets, hiring CEOs, or approving mergers. If you're the one setting the direction, you're calling the shots. It's a useful idiom for describing power dynamics in the workplace. So now let's wrap up with a big picture look at labor law, and specifically labor law in Costa Rica as an example. As a labor lawyer, this is the kind of language you'll need to explain to clients, both employers and employees. First, the labor code is your go-to reference. It's designed to protect both sides, but employers need to be especially careful about compliance. Contracts are essential. Unlike in the United States, where at-will employment can end at any time, in Costa Rica, a written contract is critical. It defines the terms, the limits, and obligations. Work hours in Costa Rica, the law generally sets a maximum of 48 hours per week, and overtime isn't optional. It must be paid fairly. Benefits are broad. Vacation, sick leave, and 4 months of maternity leave are guaranteed by law. And let's not forget the Caja. That's the national security system. Every employer has to contribute. So, what happens if these rules aren't followed? You're looking at fines, court cases, and serious damage to your company's name. This is why legal guidance is so valuable in employment relationships in Costa Rica and across the world. Great work today. We covered a lot of ground, and all of it is essential for lawyers working in labor and employment law. First, you learned key vocabulary that comes up in contracts, words like at will, non-compete, and severance. These aren't just terms, they define how someone's job begins and how it can end. Then we focused on grammar that really matters in legal writing and speaking, verb patterns, and relative clauses. These tools help you sound clear, accurate, and professional. Now, it's more than anything, you practice how to talk confidently about employment relationships, the kind of language lawyers use every day to protect their clients' rights and avoid future disputes. This is the foundation of solid legal advice, and it's what makes you a trusted legal communicator. Great job, and see you in the next lesson. Workplaces are not only about contracts and salaries. Sometimes they are about conflict. An employee might say, I was dismissed or fired unfairly. A manager might complain, the union is refusing to cooperate. A company may face a claim of harassment or discrimination. As lawyers, we must explain the process of resolving workplace disputes clearly, step by step. In this lesson, we will explore how disputes begin, the vocabulary for different types of conflicts, and how lawyers guide clients towards solutions like mediation, arbitration, and settlement. We'll also practice using modal verbs like should, must, may, ought to give advice and explain obligations in these contexts. By the end of today's lesson, you will use vocabulary like grievance, mediation, arbitration, discrimination, harassment, unfair dismissal, settlement, and collective bargaining. You will use modal verbs like should, must, may have to explain obligations and give advice. You will apply legal phrases such as file a grievance, resolve a dispute, reach a settlement, bring a claim for unfair dismissal, and use key expressions like duty of care, equal treatment, hostile work environment, and good faith negotiation. This will give you the tools to explain workplace conflicts in clear, professional English. Let's begin with the story. In a company in Ireland, an employee believes she was dismissed unfairly. She tells her lawyer, I want to fight this. What can I do? The lawyer explains the steps using clear sequencing. First, you should file a grievance with your employer. This is the formal way to raise the issue. Then, if the grievance is not resolved, the company may suggest mediation. This means a neutral person helps both sides talk and find an agreement. After that, if mediation fails, you may have to go to arbitration or even court. Finally, if you win, you could reach a settlement or even be reinstated. The lawyer also explains rights. You must be treated with equal respect under employment law. The employer ought to show a duty of care towards employees, and both sides should negotiate in good faith. This story shows how legal English helps us explain workplace disputes step by step, not just the problem, but the possible solutions. A grievance is an official complaint raised by an employee. It can be about pay, safety, discrimination, or treatment at work. For example, the employee filed a grievance about unsafe working conditions. Let's look at a story. A nurse in a hospital feels her shifts are unfair and unsafe. She files a grievance with management saying, I am being asked to work 16 hours without proper breaks. The lawyer explains a grievance is the first formal step to raise problems. It shows that the employee followed procedure before taking legal action. Grievances are the starting point for many workplace disputes. Mediation means using a neutral mediator to help both sides talk and find a solution. The mediator does not decide, they only guide the discussion. For example, the dispute went to mediation instead of court. Let's look at a story. A teacher claims she was harassed by her supervisor. Instead of going to court, the school suggests mediation. The mediator listens to both sides and helps them reach a compromise. The lawyer tells the client mediation is faster and less expensive than trial. You should consider it before going further. Mediation is a common resolution tool in employment law. Arbitration is stronger than mediation. Here, an independent arbitrator listens to both sides and makes a binding decision. For example, the union agreed to arbitration to resolve the contract dispute. A group of factory workers argue with management about wages. After failed mediation, the case goes to arbitration. The arbitrator decides the workers will receive a 5% raise. The lawyer explains, unlike mediation, arbitration produces a final decision that both sides must accept. Arbitration is often used in labor disputes and union negotiations. Discrimination happens when someone is being treated unfairly at work because of personal characteristics like race, gender, or age. For example, she filed a claim of discrimination after being denied promotion. Let's look at a story. A 55-year-old employee is repeatedly told she is too old for leadership roles. She is denied promotion while younger, less experienced workers are promoted. Her lawyer explains, this is age discrimination. You have the right to equal treatment under labor law. Discrimination is one of the most common sources of workplace disputes. Harassment means repeated or serious unwanted behavior. bullying, sexual comments, threats that make the workplace hostile. For example, the company faced a lawsuit for workplace harassment. Let's imagine a story. An employee is constantly mocked by colleagues for his accent. Another receives repeated unwanted messages from her supervisor. The lawyer explains both cases are harassment. The law protects employees from hostile work environments. Harassment cases often lead to mediation, settlement, or court claims. Unfair dismissal means an employee was terminated in violation of labor law without cause, procedure, or fairness. For example, the worker brought a claim for unfair dismissal. Let's look at a story about a receptionist. A receptionist is fired suddenly without warning, even though her performance was good. The lawyer explains you may bring a claim for unfair dismissal. The employer must show a valid reason and follow fair procedure. Unfair dismissal is one of the most serious disputes between workers and employers. Collective bargaining happens when a union negotiates with management on behalf of many workers. The union entered into collective bargaining with management. Let's take a look at a story. A union representing bus drivers demands higher wages. Management refuses at first, but later meets with union leaders. They agree to a 10% raise after weeks of collective bargaining. The lawyer explains collective bargaining protects workers by giving them a stronger voice in negotiations. This term is central to labor law worldwide. A settlement is when both sides agree to end the dispute without going through a full trial. It often involves compensation or specific terms. For example, the parties reached a settlement before trial. Let's look at this story. An employee sues for harassment. Before the case reaches court, the employer offers financial compensation and promises new workplace policies. The employee accepts, and the lawyer explains this is a settlement. Both sides avoid the cost and uncertainty of a trial. Settlements are very common in employment disputes. In workplace disputes, lawyers often give advice, not orders. For this, we use should or ought to. Both mean it's a good idea, but not an absolute requirement. For example, you should file a grievance first. This is advice for the employee. Or the employer ought to consider mediation. This suggests the employer take a positive step. Let's look at a story. A worker says, I feel discriminated against. What should I do? The lawyer replies, you should file a grievance with HR. You ought to keep a record of all incidents. That way, you have evidence if the case goes to arbitration. These modal verbs help us give professional recommendations without sounding too strong or forceful. Sometimes the law requires action. For this, we use must. Other times, the action is not certain but possible. Then we use may have to. Let's look at example 1. Employers must provide a safe workplace. This is a strict legal obligation. Or example 2. You may have to go to arbitration if mediation fails. This shows a possible requirement. Let's look at this story. An employee asks, can I refuse to return to work if the conditions are unsafe? The lawyer explains, no, your employer must provide a safe environment. If they fail, you may have to bring a legal claim. These modal verbs allow us to explain rules, duties, and possible next steps in workplace disputes. To file a grievance means to make an official written complaint about something at work. Unsafe conditions, unfair treatment, discrimination. For example, the employee filed a grievance with HR. Let's look at a story. An office worker feels harassed by her supervisor. The lawyer advises, First, you should file a grievance. This starts the formal process and shows you tried to resolve the issue internally before going to court. Filing a grievance is often the first legal step in workplace disputes. To resolve a dispute means to find a solution through negotiation, mediation, arbitration, or court. For example, the parties resolved the dispute through mediation. Let's take a look at this example. A group of workers demand higher pay. Management refuses at first, but after mediation, both sides agree to a 5% raise. The lawyer explains the dispute was resolved fairly. Neither side had to go to court. Resolving disputes is the ultimate goal of labor law. To reach a settlement means to make an agreement that ends the dispute without a full trial. For example, the company reached a settlement with the dismissed worker. Let's look at a story. An employee claims discrimination. Instead of a long trial, the employer offers financial compensation and a promise of new workplace policies. The employee accepts. The lawyer explains, you reached a settlement. This avoids the cost and risks of court. Settlements are very common in workplace disputes. To bring a claim for unfair dismissal means to start legal proceedings because an employee was fired without fair reason or without following procedure. For example, the worker brought a claim for unfair dismissal after being fired without notice. Let's look at this one. A store clerk with excellent performance is suddenly fired because the manager wants someone younger. The lawyer explains, you can bring a claim for unfair dismissal. The employer must prove the dismissal was fair and legal. This phrase is critical in employment law. It protects workers from being dismissed without cause. Employment law uses some key expressions to describe rights and duties in workplace disputes. Duty of care. Employers must protect the health, safety, and well-being of staff. For example, the company failed in its duty of care by ignoring safety rules. Equal treatment. All employees should be treated fairly without discrimination. An example, the court found the employer had violated the principle of equal treatment. Hostile work environment. Harassment or intimidation that makes the workplace unbearable. For example, repeated insult created a hostile work environment. Good faith negotiation. Both sides must make an honest effort in resolving disputes. For example, the union accused management of failing to negotiate in good faith. Constructive dismissal. When conditions are so bad that the employee resigns, but the law treats it as unfair dismissal. For example, the worker claimed constructive dismissal due to constant harassment. Industrial action. Collective worker actions like strikes or work stoppages. For example, the employees took industrial action after failed negotiations. These expressions allow you to explain not only the conflicts, but also the principles of fairness and resolution in employment law. Let's bring everything together with a real-life story. A factory worker in Germany is suddenly dismissed. He feels it was unfair and goes to his lawyer. The lawyer explains step by step using modal verbs in key terms. First, you should file a grievance with the company. That's the formal way to start. Then, if the issue is not resolved, the employer may have to attend mediation. Both sides ought to negotiate in good faith. After that, if mediation fails, the case could move to arbitration or even court. Finally, it's possible to reach a settlement before a full hearing. In this case, the lawyer highlights the worker's rights. Your employer must respect the duty of care and the principle of equal treatment. If they fail, you can bring a claim for unfair dismissal. After mediation, both sides agree on compensation and the worker is satisfied. The lawyer concludes the dispute was resolved fairly without going to court. This story shows how vocabulary, grammar, legal phrases, and key expressions all work together to explain workplace disputes in clear legal English. Let's review today's lesson on workplace disputes and resolutions. First, we practice vocabulary, terms like grievance, mediation, arbitration, discrimination, harassment, unfair dismissal, collective bargaining, and settlement. These words describe the most common workplace conflicts. Second, we focused on grammar, modal verbs, should and ought to for giving advice, must for strict legal obligations, and may have to for possible requirements. Third, we studied legal phrases. File a grievance, which means to start a formal complaint. Resolve a dispute, to find a solution. Reach a settlement, to be able to agree before trial. Bring a claim for unfair dismissal, which is to challenge a wrongful termination. Fourth, we explored key expressions: duty of care, equal treatment, hostile work environment, good faith negotiation, constructive dismissal, and industrial action. These terms explain the principles behind employment law. Finally, we told a wrap up story of a worker who was unfairly dismissed. We saw how the lawyer explained each step, from grievance to mediation to settlement, using modal verbs and professional legal English. Now, you can explain workplace disputes clearly, showing both the process and the rights involved. In today's world of work, not everyone is a traditional employee. Many people are hired as independent contractors, freelancers, consultants, designers, or delivery drivers. But what is the difference between an employee and a contractor? It matters for taxes, benefits, rights, and legal responsibilities. A company might ask, should we hire this worker as an employee or a contractor? A worker might ask, am I entitled to benefits or am I just an independent contractor? In this lesson, you'll learn how to explain the legal differences between employees and contractors step by step in clear legal English. By the end of today's lesson, you will use vocabulary like employee, independent contractor, payroll, benefits, tax withholding, supervision, termination, and misclassification. Explain the rights and responsibilities that differ between employees and contractors. You will also practice grammar, present simple versus the present continuous, to describe fixed duties, for example, employees work fixed hours, versus ongoing tasks. The contractor is working on a project. You will apply legal phrases such as classify a worker, issue a contract, provide benefits, terminate an agreement. This will help you explain employment status clearly to clients and colleagues. Let's begin with the story. A small tech company in Poland hires a software developer. The manager asks the lawyer, should we hire her as an employee or as an independent contractor? The lawyer explains step by step. An employee works under supervision, follows company rules, and is on the payroll. The employer must provide benefits like health insurance and paid leave. An independent contractor is different. She works on her own schedule, sends invoices, pays her own taxes, and is not entitled to employee benefits. If you classify her wrongly, the company may face legal problems. This is called misclassification. The manager nods. So, if she works long term in our office under our control, she is an employee. But if she works on short projects independently, she is a contractor. This story shows why the distinction is important and how lawyers must explain it in clear, practical English. An employee is someone who works for a company under an employment contract. They follow company rules, work fixed hours, and are usually entitled to benefits like paid leave, health insurance, and pension contributions. For example, the company hired 10 new employees. Let's look at a story. A retail shop hires cashiers. The lawyer explains they are employees. They must follow schedules set by the employer and are protected by labor law, including minimum wage and benefits. Employees are the core of traditional labor law. An independent contractor is not on the payroll. They are self employed, provide specific services, and manage their own taxes. They are not entitled to employee benefits. For example, the company hired a graphic designer as an independent contractor. Let's look at a story. A lawyer explains if you pay a designer for one project and she works from home on her own schedule, she is an independent contractor, not an employee. This status gives flexibility, but fewer protections. Payroll means the system where employees are officially registered and paid by the company, including salary, benefits, and tax withholdings. For example, all company employees are on the payroll. Let's check out a story. A business owner asks, do I need to add this worker to payroll? The lawyer explains, if she's an employee, yes. Payroll ensures taxes and benefits are paid. But if she's a contractor, she issues her own invoices and is not on payroll. Payroll is the key legal line between employees and contractors. Benefits are extra advantages employees receive beyond salary. This includes health insurance, paid leave, pensions, and sometimes bonuses. For example, employees receive benefits like paid holidays. Let's look at this story. A worker compares contracts. Job A offers higher salary, but no benefits. Job B offers health insurance, holidays, and pension. The lawyer explains those are employment benefits. Contractors usually do not get them. Benefits are one of the biggest differences between employees and contractors. Tax withholding means the employer deducts income tax and Social Security contributions directly from an employee's paycheck. For example, the employer is responsible for tax withholding. Let's check out a story. An employee asks, why is my paycheck lower than my salary? The HR officer explains, because we withhold tax and pay it to the government for you. Contractors, by contrast, must handle their own taxes. There is no withholding. Supervision means control. Employees work under the employer's direction. They follow schedules, company policies, and orders. Contractors, on the other hand, have independence. For example, employees usually work under close supervision. Let's look at a story. A restaurant hires waiters. The manager decides shifts, uniforms, and behavior rules. The lawyer explains this is supervision. If the worker must follow daily orders, they are likely an employee. Supervision is one of the main tests courts use to classify workers. Termination means ending a working relationship, either an employment contract or a service contract. For example, the contract was terminated after 6 months. Let's take a look at a story. An employee is dismissed for repeated lateness. A contractor finishes a 6-month project and the agreement ends. The lawyer explains Both are terminations, but employment law offers employees protections like notice periods and severance pay. Contractors usually just end when the project is over. Understanding termination helps lawyers explain rights at the end of a working relationship. Misclassification happens when an employer incorrectly labels a worker as a contractor instead of an employee, usually to avoid paying benefits or taxes. For example, the company was fined for misclassification of workers. Let's look at a story. A delivery company calls drivers independent contractors, but the drivers wear uniforms, follow strict schedules, and work only for that company. A court later rules they were misclassified. They are employees and must receive benefits. Misclassification is a serious legal risk for companies and a frequent source of disputes. The present simple is used to describe regular duties, rules, or general truths. Example, employees work fixed hours. This describes a typical duty of employees. The second example, the employer provides benefits, a fact about employment. Third example, contractors issue invoices for their services. This is how contractors get paid. Take a look at a story. A lawyer explains to a client an employee works under supervision and receives benefits. Contractor works independently and issues invoices. Notice that all verbs are in the present simple because we are describing fixed roles and ongoing truths, not temporary actions. The present continuous is used to describe ongoing or temporary actions. For example, the contractor is working on a new website project. The work is happening now, but it will finish soon. Example 2. The employee is attending a training course this week, a temporary situation. And the third, they are negotiating a new contract, an action happening right now. Take a look at another story. A company hires a consultant. The manager says, she is working with us on a 6-month project, but she does not work for us full time. She is an independent contractor. The present continuous shows the temporary, project based nature of the work, which is typical for contractors. To classify a worker means to legally decide their status, employee or contractor. This classification affects taxes, benefits, and rights. For example, the company must classify workers correctly to avoid legal risks. Let's take a look at an example. A delivery platform calls its drivers contractors. But the drivers, they wear uniforms, they follow schedules, they use company vehicles. And the lawyer warns the company, if you classify them as contractors, it could be misclassification. Legally, they are employees. This phrase is critical because misclassification can lead to fines and lawsuits. To issue a contract means to create and deliver a formal written agreement that defines rights, duties, and terms of work. For example, the company issued a contract to the new employee. Look at a story here. A startup hires a consultant for 6 months. The lawyer explains you must issue a contract for services, not a contract of employment. This makes clear she is an independent contractor. Issuing the correct contract is essential for defining the working relationship. To provide benefits means to give employees extras beyond their salary, such as health insurance, vacation pay, or pension contributions. Contractors usually do not receive these. For example, employers are required to provide benefits to full-time employees. Let's look at a story. An employee compares 2 jobs. Job A pays more but has no benefits, and Job B includes health insurance, paid holidays, and a pension. The lawyer explains only employees are entitled to benefits. Contractors manage their own. Providing benefits, like we talked about before, is one of the clearest signs of employment status. To terminate an agreement means to formally end a contract, either by expiration, mutual consent, or breach. For example, the company terminated the contractor's agreement after the project ended. Let's look at a story. A software developer works as a contractor for 6 months. When the project is complete, the company terminates the agreement. The lawyer explains termination for contractors is simple. The project ends. But for employees, termination is more complex, with notice periods and possible claims for unfair or wrongful dismissal. This phrase is key to explaining the difference between employment and contracting relationships. Here are some key expressions used in worker classification cases. Control test. Courts ask, does the company control how, when, and where the person works? For example, the judge applied the control test to decide if the driver was an employee. Economic dependence. If a worker relies on one company for income, they may be considered an employee. For example, her economic dependence showed she was not truly self employed. Flexible work arrangement. Work that is not traditional 9 to 5. Remote work, part time, or freelance. For example, the consultant enjoyed a flexible work arrangement. Statutory rights. Rights protected by law, such as minimum wage, safe conditions, or paid holidays. For example, employees cannot waive their statutory rights. Gig economy, which is short term or app based work like delivery drivers or ride sharing. For example, the gig economy has created many disputes about employment status. Severance pay. It's compensation for employees when their job ends. Contractors usually do not receive it. For example, the dismissed worker received 6 months of severance pay. These expressions help lawyers explain the tests, rights, and modern realities of distinguishing contractors from employees. Let's finish with the full story. A small marketing agency in Canada hires a social media specialist. The owner asks the lawyer, is she an employee or a contractor? The lawyer explains step by step. First, let's look at her duties. She works regular hours in your office under supervision. That suggests she is an employee. Then let's check payroll and benefits. If she receives health insurance or paid leave, she must be on payroll as an employee. After that, we apply the control test. If you decide her schedule, tasks, and tools, she is under your control. We also ask if she has economic dependence. Does she work only for you? If yes, she's more like an employee than a contractor. So finally, we must classify her correctly. If you misclassify her as a contractor, the company may face fines, back pay, and liability for missed benefits. The owner nods and says, so, if she's working long term under our direction, she is an employee. But if she was doing a short project independently, she could be a contractor. The lawyer concludes, exactly. Correct classification protects both the worker's rights and the company from legal risk. This story shows how vocabulary, grammar, legal phrases, and key expressions come together to explain worker status clearly to clients. Let's review today's lesson on independent contractors versus employees. First, we practice vocabulary, terms like employee, contractor, payroll, benefits, tax withholding, supervision, termination, and misclassification. These words help explain employment status clearly. Second, we studied grammar, present simple for fixed duties, employees for fixed hours, present continuous for ongoing temporary actions. The contractor is working on a project. And third, we used legal phrases. Classify a worker, which is to decide employee or contractor. Issue a contract, which is to provide a written agreement. Provide benefits, which is to give employees health insurance, holidays, etc. Terminate an agreement is to end the working relationship. And fourth, we explored key expressions, control test, economic dependence, flexible work arrangement, statutory rights, gig economy, and severance pay. These are essential for modern labor law. Finally, we told a wrap up story where a lawyer explained worker classification step by step, using vocabulary, grammar, and legal phrases to avoid misclassification. Now you can confidently explain the difference between contractors and employees in clear, professional legal English.